And welcome to the Legal Lounge here on CRN Digital Talk Radio, CRNTalk.com, streaming live coast to coast around the world on CRNTalk.com, on CRN's custom-built Roku channel, available in the Roku store, on TikiLive.com, and of course, on CRNTalk.com. I'm joined, as always, by the one and the only, an active attorney, U.S. Army veteran, Juris Doctorate in Law, undergraduate degree in physics, and author of a book that has proven to be a guideline for the Supreme Court now and in the future. That book, America: An Illusion of Freedom, is available on Amazon, Barnes & Noble, and on iTunes. You can check them out on AM 870 The Answer. Ladies and gentlemen, Mr. Richard Nixon, and the show that gives you the news you get nowhere else. How are you, Richard?
I'm very good. Thank you very much. In our show prep, we discussed the fact that I think we're both a bit disappointed with the recent Supreme Court oral arguments in that they didn't seem to get much into birthright citizenship. But we'll get into that a little bit later. Yeah,
we're going to talk about that extensively, of course, but we should mention the passing of a very interesting and highly regarded individual, Mr. David Horowitz. You might remember him. He did a lot of consumer advocacy. He had a very interesting life. Started out as an avowed Marxist.
Yes, he did.
And then kind of came to his senses in the 80s and became a consumer advocate and conservative thought leader, more of a libertarian bent, Richard. But I know you were a fan of his.
Well, I was, at least later when he became, if you will, a more of a conservative. He wrote a little piece here about 10 reasons for why he thinks or thought reparations for slavery was not a good idea. And I'm just going to read, he's got, like I said, there's about 10 reasons here. I'm only going to read number 2. And what he says here is this. The claim for reparations is premised on the false assumption that only whites have benefited from slavery. If slave labor had created wealth for Americans, then obviously it has created wealth for black Americans as well, including the descendants of slaves. Now, this is interesting. The GNP, or the gross national product of black America, makes the African community the 10th most populous nation, in quote marks, in the world. American blacks, on average, enjoy per capita incomes in the range of 20 to 50 times that of blacks living in any of the African nations from which they were taken. Now, again, that seems to be, assuming that statistic is true, is cause to reflect on whether or not the blacks in this country need any further, if you will, help. And also, I'm going to read number 9. He says that slavery existed for thousands of years before the Atlantic slave trade and in all societies. But in the 1,000 years of slavery's existence, there never was an anti-slavery movement until white, underline that, white Anglo-Saxon Christians created one. If not for the anti-slavery beliefs and military power of white Englishmen and Americans, the slave trade would not have been brought to an end. If not for the sacrifices of white soldiers and a white American president who gave his life to sign the Emancipation Proclamation, blacks in America could very well still be slaves. If not for the dedication of Americans of all ethnicities and colors to a society based on the principle that all men are created equal, blacks in America would not enjoy the highest standard of living of blacks anywhere in the world, and indeed one of the highest standards of living of any people in the world, period. They would not enjoy the greatest freedoms and the most thoroughly protected individual rights anywhere. Where is the acknowledgement of black America and its leaders for those gifts?
All right, there you have it from David Horowitz. Rest in peace, sir. We'll be right back. Stay with us. Yeah, very nice reading, Richard. We're going to do the whole birthright citizenship. I'll set it up for us. Yeah, so have your Wonka mark handy here. And we are back at Legal Lounge. Once again, thank you so much for joining us. As always, all past and previous sessions of this high-quality broadcast are available on YouTube, also on Rumble. We're live streaming on Facebook at crntalk.com/podcast. Excuse me, crntalk/facebook.com/crntalk. And also we're available as a podcast at crntalk.com/podcaster. All right, Richard, oye, oye, oye. Both you and I woke up bright and early yesterday to listen to the oral arguments for a case that we have been covering extensively, something that you've written about very eloquently, extensively in your fantastic book, America: An Illusion of Freedom. This is Trump versus CASA, Trump v. Washington, Trump v. New Jersey et al. I was a little bit, I think both you and I were a little bit disappointed, you might say, that the case was not argued on the merits. This is more about arguments over a technical question having to do with nationwide injunctions and temporary restraining orders.
Yes.
Your thoughts listening to the case first, Richard, and I want to get your take on this.
Well, again, I feel the same way. During our show prep, we discussed the fact that we were prepared to hear birthright citizenship and whether or not the Supreme Court was going to go around. Well, actually, they were going to entertain arguments regarding whether or not Trump's executive order regarding birthright citizenship was going to be, they weren't going to decide it. They were simply going to discuss it. However, what happened is they really got off on a tangent into discussing nationwide injunctions as opposed to, which is also important here in the context of Mr. Trump. He's got something like 40 executive orders that were and are being countered by injunctions or TROs, and they're all nationwide. And Mr. Trump decided, I think his attorneys decided, well, why don't we just talk about or discuss the merits of the nationwide injunctions? And again, we have an article written by Margot J. Cleveland. She is an attorney. And she agrees with us, that is to say, that the nationwide injunctions are clearly against the Constitution. And very briefly, Mike, I want to say this, that we've got a federal district court judge who does not exist in the Constitution. He is created by Congress. And Article 3 of the Constitution talks about the fact that the Constitution creates the Supreme Court, but Congress creates all these lower federal court judges. This is a judge that does not exist in the Constitution by way of creation. However, we have these federal local district court judges basically ordering or controlling what the president can do in his role as president. Now remember, Article 2, Section 1, Article 2, Section 2, Clause 3 says basically that the president shall take care that the laws be faithfully executed. He is being hampered from executing his role, that he makes sure that the laws of the country are executed. His position regarding birthright citizenship is correct, and this particular judge, well, there's like 40 of them, are going against Mr. Trump, and they are a violation of the Constitution.
Yeah, Mr. Sauer, the Solicitor General who argued this case we're discussing before the Supreme Court, he mentioned that there's 688 federal judges right now that have the power to unilaterally pretty much make policy for the entire nation and to usurp the will of the people by turning, President Trump campaigned on any birthright citizenship and won the election. And going back to Ms. Cleveland, she had a great quote here from her article, which somehow snuck past the Daily Journal censors over there. Article 3 of the Constitution extends judicial power only to cases and controversies. Such power authorized federal courts to provide relief to the parties before it. But as the Trump administration aptly argued in its application, courts cannot grant relief to strangers to the litigation. Yet that is precisely what the lower courts did in joining the enforcement and implementation of a birthright citizenship EO through the United States. And that was one of Mr. Sauer's arguments as well. And he had a great line here too, Richard, that I believe you and I both, I think is apt for this discussion, these nationwide injunctions and TROs, quote, they operate asymmetrically, forcing the government to win everywhere while the plaintiffs can win anywhere.
Exactly. And another thing that Miss Cleveland, to her credit, mentioned here is in issuing the nationwide injunctions in the birthright cases, the lower courts have exceeded their Article III authority in a second way, with the judges ignoring the constitutional requirement of standing. To seek relief from a federal court, a plaintiff must have standing or a concrete and particularized injury caused by the defendant. Without standing, there is no actual case or controversy, and thus no Article III authority. The Supreme Court has further clarified that a plaintiff must establish standing for each form of relief that they seek. Now, these people who might be part of the so-called nationwide injunction, they might be enjoying or even opposing the result of the injunction, whether it was granted or denied. But the point is they have not gone through the so-called standing criteria. They don't necessarily have any case or controversy before the Supreme Court, and therefore the courts should not be extending authority, or nor should this federal judge, to those people other than the people who are a party to the case before the particular federal district court judge.
I was confused about the standing issue yesterday as well, listening to these oral arguments in this Casa versus Trump case, because you had the government on one side, and then you had several parties on the other side.
Yes.
You had a class of private individuals, and you had several states arguing as well. And the standing of the state, specifically New Jersey, the argument of the attorney from New Jersey representing New Jersey, was saying he wasn't experiencing an injury. He was arguing that that the state of New Jersey was going to have an injury because somehow, through some really weird argument, if they did end by birthright citizenship, New Jersey and other states would therefore have to then pay for the benefits of illegals and their children themselves.
Yes, and again, I don't know which one of the liberal women there on the Supreme Court said it, but something to the effect that what about a baby that's born in the hospital? They won't know whether that baby's a citizen or not. Well, we're talking prospectively. When courts don't deal with that, they do a deal in general. Before you have a case in controversy, someone has to be injured, and that's why they're before the court. They can't say to the judge, Your Honor, I might be hurt next week. Can you handle this case? Guess what? Our boy George Washington tried that. As president, he sent a letter to the Supreme Court and asked them for advice. Would this be constitutional, justices? And the justices told him, hey, George, we love you, but we can't decide this unless there's a real case or controversy. And the good reason for that, Mike, is this, as you know. What the judges want before they can make a proper decision is adversarial things, both sides giving us their best arguments for why we should go their direction. If we don't have people arguing on either side or on just one side, it's not a fair hearing.
I agree. And in birthright cases, the lower courts doubly transgressed the standing requirement of Article 3. First, they permitted 20-plus states to challenge the EO, even though the state's government lacked a concrete and particularized injury.
Exactly.
So, Richard, we're going to be right back. We're going to talk more about this. This is a fascinating discussion. Stay with us. And we are back in Legal Lounge. Thank you so much for joining us. Really appreciate it. Richard's fantastic book, America: An Illusion of Freedom, is available on wherever you find your books, Amazon.com, Barnes & Noble, and on iTunes. You can also email him, pres37th@aol.com. And if you're watching this on YouTube, Rumble, or on Facebook, that email address is on your screen right now. Okay, so we're talking about this very interesting day at the Supreme Court this week, where the birthright citizenship, and I use that in quotes because it was actually of course, President Trump, the day he took office, issued an executive order saying that he wants birthright citizenship kaput. That's something that Richard has written extensively about in this fantastic book. And the question in front of the court this week was whether or not these nationwide injunctions, which would stop the executive order, are valid or good law. And real fast, we got to talk about Justice Thomas, because Justice Thomas is, the kind of harbinger on the court about history and tradition.
Absolutely.
And so the very first question, because he gets all the very first questions because he's got senior status, was, well, let's talk about these nationwide injunctions. How long have they been around for? What's the history tradition here? And pretty much, 60s, they're saying.
Yeah.
And so that doesn't bode well for those who are a fan.
No, Trump. Justice Thomas says, well, we did fairly well without them up until 1960.
Yeah.
And then we've had a slight rash. But now it's even worse. Now that maybe every executive order that Mr. Trump, the current president, has presented has been countered with a TRO, and that TRO or nationwide injunction has also been national, for no good reason other than normally most of us deal with the situation where the judicial officer deals and has authority only with the people in front of him, in personam jurisdiction and subject matter jurisdiction. It never, to my knowledge, extends. And Justice Thomas says the same thing. Since when does it extend to people outside the jurisdiction?
Judge Gorsuch had a funny line where he was just like, look, he mentioned the fact too that there's 688 individual federal judges out there, all across the country.
Right.
And he says that, each one of these 688 federal judges is a king in his own court and sometimes acts that way. And so Sauer,
and some of them get it wrong, they say.
Yeah, exactly. He mentioned that as well. And Solicitor General Sauer arguing for the government when pressed upon, what would replace these nationwide injunctions or TROs if a large group of people had an injury that they wanted to seek redress from the government under the Constitution. It'd be class action, right?
Yes. And the thing is, Mike, now that we talk about it, the word that I would use to describe what we witnessed yesterday, that is the arguments regarding what we thought was going to be birthright citizenship, leaves me totally unsatisfied with the results. Again, we talked about this morning, that maybe they purposely avoided talking about birthright citizenship because Mr. Roberts, I should say Justice Roberts, Chief Justice Roberts, has decided it's really not an issue for the court. I think he's suggesting that maybe Congress should get on the ball and get off his rear end, and they can make the law regarding birthright citizenship very easily.
Yeah.
And rather than their making a decision. However, I think they will go forward with the nationwide thing. I think that's something that most people, in fact, I think it's Sotomayor who said some years ago that these nationwide injunctions are not good because we overpower the president, who was part of the Constitution, with a judge who is not even elected. He's appointed by Congress. Why should he have sway over a president who was 1/3 of the federal government, and he is elected by the people? That judge should not have that power.
Yeah, Kagan even said, yesterday or this week, saying that there are all kinds of abuses of nationwide injunctions. So, I mean, this is like a very highly technical question, but one thing I want to get into before we hit this next break real fast is the court was addressing, it was kind of all over the place, Richard, because of course they were supposed to argue about, the validity of the actual process of these nationwide injunctions,
right.
Whether or not this is, like you just said so eloquently, whether or not this is, good business practice. But then they brought in, a lot of stuff about the merits. And when we refer to the merits of this case, we're talking about the actual legality and practicality of ending birthright citizenship.
Right.
And I think that Mr. Solicitor General Sauer did himself a little bit of a disservice by letting some of that stuff in. But we're going to hit a break right now, and we're going to talk more about this because this is a really fascinating issue that's going to, I think, be quite cogent in the culture moving forward. Once again, make sure to check out Richard's fantastic book, America: An Illusion of Freedom. It's available on Amazon.com, Barnes & Noble, and on iTunes. And as always, you can check out all past previous sessions of this broadcast available on Rumble. Find CRN Digital Talk on Rumble. Find CRN Digital Talk on YouTube. Also, we're on Facebook at facebook.com/CRN Talk. Thanks. And we are back in the Legal Lounge. Thank you so much for joining us. And just before we hit that last break, we're talking about, of course, this case argued this week at the Supreme Court regarding birthright citizenship and nationwide injunctions and TROs. And it was supposed to be more about the technical aspects. So there's two things: the technical aspects, which is the TROs, the nationwide injunctions, and then there's the case on the merits, which is birthright citizenship, the executive order as a whole. And Richard, Amy Coney Barrett, almost all the judges, the liberal judges, and including Amy Coney Barrett, they started to talk about the case on the merits too. Did you also see Justice Sotomayor kind of get smacked down a little bit by the Chief Justice because she kept interrupting the Solicitor General? And Mr. Roberts was like, Chief Justice says, I want to hear this guy's answer.
Absolutely.
But Mrs. Barrett pretty much says, Justice Barrett said that, look, this has been already decided, birthright citizenship through precedent, through stare decisis. And she cites a case that you have written, researched, and are an expert on. And this is the Wong Kim Ark case. And this has got you kind of hopping mad, right?
Yes. What's got me going is that it looked as though at least Amy Coney Barrett, as one of the Supreme Court justices, had somewhere said that she thought the Wong Kim Ark case was pretty much dispositive of the birthright citizenship issue, and that was the law by which they would go. Now, I don't understand that, frankly. I think it's absolutely incorrect, because what the Wong Kim Ark case was, it was like the third or fourth case since the 14th Amendment, Section 1, 1868. Wong Kim Ark case is 1898, I believe. In any event, the history preceding Wong Kim Ark, even though most people, I shouldn't say most people, the left believes there's only one case. In fact, there's three cases. They all predate the Wong Kim Ark case. The first issue is coming out of my famous book on Chapter 7. It basically says that all persons born or naturalized in the United States, and, quote, and subject to the jurisdiction thereof, are citizens of the United States and of the states wherein they reside. Now, the issue is, what does that mean, and subject to the jurisdiction thereof? What Mr. Jacob M. Howard of Michigan, who is the author of the Citizenship Clause, says it means is persons born in the United States who are of foreigners, aliens, or belong to families or ambassadors, or of American Indians. They are not subject to the jurisdiction, and therefore they are not citizens. That is to say, the baby born of those parents is not a citizen. It goes on to talk, that is my book, that another case, 1872, 4 years after the 1868 14th Amendment, basically mirrors the words, and it simply says the phrase subject to the jurisdiction was intended to exclude from its operation children of ministers, consuls, and citizens or subjects of foreign states born within the United States. And last, or thirdly, we have the case of Elk versus Wilkins, 1884. This had to do with an Indian, American Indian who was born in the United States. He was born on his reservation. He wanted to vote under the 15th Amendment. Citizens were allowed to vote as of 1870, and he wanted to vote. So he said, I'm a citizen. I was born here. And reluctantly, the Supreme Court said, no, I'm sorry, but you owe allegiance apparently to your tribe, and therefore you do not owe the necessary allegiance to this country. Therefore, I'm sorry, your being born here is not an act of granting citizenship to you. Now we come to 1898, the Wong Kim Ark case, which all the liberals have jumped on because it's the only one that they can't cite for Mr. Trump. This one says between a Chinese family had a child, the child was declared a citizen because the parents were permanent legal residents. There was a treaty between China and America that said these Chinese people could not become citizens of the United States. And therefore, because these people were properly here, legally here, they were permanent legal residents, the court granting, some kind of mercy, if you will, to that extent, kind of twisted the law a little bit and said, you know what, in our case, these people have done everything they could. They are basically de facto citizens. These are my words.
Yeah.
And therefore, we will grant citizenship to their child, and that child would be able to vote, etc. So, but the point is, the Wong Kim Ark case does not stand for the basic proposition that the left is making, and that is any parent who comes here and their child is born here automatically becomes a citizen. That is not true, and it is not even supported by their case, the Wong case. The Wong case is the wrong case, as they say.
Yeah.
And what it means really is you have to at least be a permanent legal resident. You cannot come here and automatically become a citizen.
Do we think that maybe the court might go along with that view? Because they have multiple options here. The court could do is they could pretty much just only rule in the technical thing. They can say, whether or not these nationwide injunctions or TROs, whether or not that's above board. But they could also, could they rule on the merits? Could they say, hey, come back in 6 months and rule on this?
Yes, they could. And of course, the issue then becomes, as we talked about, the so-called obiter dictum, whether or not they've allowed the parties to argue. And so far, from what I saw, they didn't.
Well, they kind of did, though. I mean, because Solicitor General Sauer was pretty much saying that he used a lot of kind of the rhetoric that President Trump used about birthright citizenship, and kind of did argue it on the merits a little bit.
But some, Mike. My point is this: it has to be really adversarial.
Yeah.
It was, as I said, they tried to handle two issues at one time: nationwide injunctions and birthright citizenship. They did justice, to use that word. They did justice to neither one. I was very, very disappointed. But again, I think we know why, Mike, and that is that Chief Justice
Swinging John Roberts.
He likes to what's the word I'm looking for? Punt back to the Congress. Let Congress take care of this issue. We don't want to be responsible for upsetting so many people because the law, quote, has been misapplied for a long time. We don't want to make that sudden leap and basically going against a lot of people who are here. Anyway, these are my words.
All right, well hold that thought, Richard, because I want to get our predictions for where this is going to end up right after the break. So stay with us, you guys. We're here in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Stay with us. And we're in Legal Lounge, Sierra Digital Talk Radio, SierraTalk.com. Richard Nixon live. Check out his book, American Illusion of Freedom, available wherever books are sold. Check him out on KRLA 870 The Answer as well. And Richard, we're going to make our predictions, and I think you have it pegged. I think that Chief Justice Roberts, based on what he talked about, the way he kind of conducted the hearing itself, he seems pretty reticent to rule on this, and he doesn't, unlike Dobbs, he doesn't have an out where he can just punt this down back to the states, a decision that you and I both agree with. And this is what I think, and then I want to get your take. I think that they will modify the executive order,
Birthright citizen.
No, I think they're going to modify the form and function of the nationwide injunctions and the TROs. I think they're going to use a history and tradition test. Yeah. I think that's going to be a 5-4 decision. I think it's going to be. I think Thomas is going to argue it to write the decision. I think that there will be several justices in dissent. The 3 liberal justices, maybe Amy Coney Barrett, but I doubt it. I think actually John Roberts might write with the liberals on this. If this case does go to the Supreme Court, well, real fast, they asked the Solicitor General Sauer, let's decide this on the merits right now. Let's grant this cert. But Sauer wanted to, quote, percolate. What did that mean? What's that mean when he says he wants it to percolate?
Well, they want to send it back to the lower courts, let them make decisions, let one circuit rule A and the other one not A, and then it'll come back up to us to decide the difference. But I have to disagree with you slightly, Mike. Sure. I believe on the nationwide issue, it'll either be 7-2 or zip 9-0.
Yeah.
Because I think Sony Meyer has a tape that you've probably seen it too, where she simply said these are my words now, but these nationwide injunctions we have no place for them because judges exercise too much power this way over the president. The president should have unfettered, these are my words, unfettered authority to do as the Constitution demands, and if we don't like it, impeach him. But I think on the birthright citizenship, I think they purposely gave it short shrift because I don't think they intended to deal with that at all. And I think Chief Justice Roberts' position is not send it back, but let the Congress take care of it. It's an issue more for Congress. Again, the reason I say that is because if Congress decides it, you literally have the country deciding it. If these people, 9 unelected lawyers in robes, as Scalia would say, you've got 5 or 6 or 8 or 9 people discussing, people who were never elected, deciding this tremendous issue. No, it's got to go back to Congress.
I completely and wholeheartedly agree with you that this issue should be decided. The merits about birthright citizenship should be decided by Congress.
Yes.
I mean, I was frustrated, and I told you in our prep session that I listened to the whole thing, and I did not hear a phrase that I had my ears perked up for, which was the major questions doctrine, where we've seen before in the eviction moratorium and the student loan that this is such a major issue.
And I think that's why, even though they mentioned birthright citizenship in the EO, I think what they were really concerned with here, and it turns out to be right, that we're only concerned with nationwide injunctions. If we can get that reduced, then here's the other thing that we talked about maybe last time that people have asked me about. Mr. Trump could start on his new issue of injunctions. In executive orders. And because we have a holding by the Supreme Court that says the plaintiffs or the moving party on these TROs and injunctions do not get attorney's fees, he will be free to make these, and maybe nobody will oppose them.
Well, it become a de facto win if the court does then strike down these nationwide injunctions, but then lets the actual merits of the case percolate. Because if the injunctions are then struck down, then the only redress by those who would be affected would be to get a class certification, which takes time, and they would have time to actually enact the policy for the months, if not years, before it's up to the Supreme Court to hear it on its merits.
Okay, but see, you added something to it. I don't know whether or not they're asking that the nationwide injunctions be stricken. I think he's only talking prospectively from now on. Now, I could be wrong. but I haven't been able to figure out whether or not.
Well, that was addressed actually in because they asked him about that. Like, well, if we do strike this down, will the policy take effect? And then Solicitor Sauer said no, because in the executive order itself, there's a 30-day wind-up period.
Okay, great. If that's the case, I didn't catch that, Mike. I stand corrected.
Well, I appreciate that. So, I mean, this is definitely, it's going to be fascinating if they argue this on the merits.
Yeah.
I mean, I think that I mean, obviously, you and I both think that this should be debated in the well of the Congress rather than debated in the Supreme Court.
Yes.
So, but if they do debate this at the Supreme Court, I think that's going to be a really fascinating argument.
Not only that, but see, Senator Grassley has already said that when it comes to nationwide injunctions, they're prepared to pass laws to deny it anyway. So, this kind of
if they can get past the filibuster.
Well, now that's interesting.
My thing is you have to get rid of. I mean, you got to get rid of the filibuster. I mean, I think you and I disagree about that.
But would a filibuster be appropriate in something like that?
To change the rules of how the courts could work under Article 3?
Yeah.
I mean, that's something for the parliamentarian, I think, to work out.
Right. And what's the other word when you don't need to you go around the filibuster because all you're dealing with is taxes, spending, and some other things.
Yeah, it's because it's
only with the budget. What do you call reconciliation?
Reconciliation.
Now,
if they can tack that on, I don't know. We're gonna have to get our research staff on that. Stick around. We're out of time in this segment. We want to come back and wrap things up and talk about semi-friend of the show, Erwin Chemerinsky. Stay with us. Okay, during the break, we had our crack research team. They were working furiously, and they brought us a lot of information here. So the question was, well, I think Rich and I both agree that the court's going to do something about these nationwide injunctions, but they're going to punt the issue about the merits of birthright citizenship and the legality of that executive order back to Congress. And so the question became, all right, well, can Congress do anything about these nationwide injunctions? Probably not, because of the filibuster. Can they do anything about birthright citizenship? Can Congress do anything about birthright citizenship but probably not because of the filibuster. But when it comes to the nationwide injunctions, which Richard and I, both you and I, do not like, there is something that our crack research team brought to our attention, and this is the Federal Rules of Civil Procedure number 65.
Right.
And what are the Federal Rules of Civil Procedure? The Federal Rules of Civil Procedure govern civil procedure in the United States District Courts. They are the companion to the Federal Rules of Criminal Procedure. These rules are promulgated, that means made up and regulated.
Layman's terms, yes.
Regulated by the United States Supreme Court.
Wow, see, we
pursuant to the Rules Enabling Act.
Wow.
However, so the United States Supreme Court can amend, change the Federal Rules of Civil Procedure, and one of those rules, number 65, talks about these nationwide injunctions. They can change those, but within 7 months, unless Congress has the power to veto that.
You know what? Now that I think about it, it makes sense. It's just like Congress is here, they make the laws, but over here you got the president that will enforce the laws, and now over here you're saying the judiciary, we're going to give you some freedom to make up your own rules, which is what they're doing, so they can function properly. So it makes sense that Congress would give it to them with a leash. 7 months, we can withdraw it if you guys are screwing up.
The crack research team just passed me a note too, and you know what's interesting about this Rules Enabling Act, which puts the check on the court from Congress.
Yes.
1934.
Right.
What was going on around 1934, the New Deal and a lot of the incorporation doctrine.
Not only that, but it's consistent with Article 3, Section 2, Paragraph 2, which we've talked about before, that basically says that Congress can at any time withhold jurisdiction from the Supreme Court regarding law and ethics and so on as they choose. So they can pass a law, ABC, and say the Supreme Court does not have jurisdiction to hear this case. And they've done that in my book, Ex Parte McCardle. McCardle. And it's in the book. And this is consistent with the idea that we don't have a pure separation of powers. We have some interplay between, but it's usually Congress being at the head of all this stuff.
Yeah, as it should be, because it's Article 1 is Congress, it's the people's branch.
And they're responsible to us. That's how it should be.
Yes, exactly. And every 2 years for the House of Representatives as well. So that's the most kind of closest metal to the meat part of democracy. All right, well, we're getting close. Right? We got about a minute.
Oh, but come on. We have to look at the guys. Thomas Jefferson and James Madison, and I was going to throw Richard Nixon in there, but I can't. George Washington. These guys knew what they were doing. The more we find out about this Constitution, the more they knew. Well, I would say never mind. They had their stuff together. Let's put it that way.
They did. They were smart guys, and a constructionalist and a contextualist. I think if we do see the birthright citizenship case argued in front of the Supreme Court on the merits, we're going to see a lot about the history and tradition about why the 13th, 14th, and 15th Amendment were ratified and passed in context shortly after the Civil War.
Exactly.
And that birthright citizenship and those amendments were solely to give freely emancipated slaves citizenship.
Very, very well said, Mike.
Thank you very much, Richard. And on that note, folks, we'll see you guys next week here in the Legal Lounge. Take care.